Good afternoon, everyone. I'm Tamiko Brown-Nagin, Dean of the Harvard Radcliffe Institute, and I'm happy to welcome you to this afternoon's program, 20 Million Angry Men, a conversation about the importance of including people with felony convictions in our jury system. Our discussion today is presented as a part of the Institute's Law, Education, and Justice focus area, and it's a collaboration with Harvard Law School's Institute to End Mass Incarceration. I'm particularly pleased to partner with the Institute to End Mass Incarceration in presenting this program, which focuses our attention on a topic that's both fundamental to our legal system and yet one that receives comparatively little attention in conversations about reform. As many in the audience know, more than 2 million people are incarcerated in the United States. This historically high rate of incarceration constitutes a national crisis, and its impact is broad and deep, including profound civic, family, social, and educational effects. Yet the consequences are not borne equally. Low-income communities and communities of color, particularly African American and Latinx communities, are disproportionately impacted. In 2019, Black adults were imprisoned at more than 5 times the rate of white adults. Hispanic adults were imprisoned at nearly 3 times the rate of white adults, according to Department of Justice data. These disparities are the result of multiple overlapping systemic challenges. Today, we focus on one in particular, namely the fundamental right to a trial by jury of one's peers, and one way our legal system may still fall short of upholding that right. The Sixth Amendment to the U.S. Constitution establishes the right of defendants in criminal prosecutions, and it specifically includes the right to an impartial jury. The question of what constitutes an impartial jury of one's peers has long been debated. But more than a century's worth of case law has established the cross-section doctrine, which holds that a jury must be assembled from a pool that is broadly representative of the community. The importance of jury diversity is clear. To quote Justice Thurgood Marshall, when any large and identifiable segment of the community is excluded from jury service, the effect is to remove from the jury room qualities of human nature and varieties of human experience. Yet, as we'll hear today, people with felony convictions are still subject to restrictions on jury service in every state except Maine, and anyone with a felony conviction is permanently barred from jury service in 26 states and in federal courts. Advocates have sought to overturn these exclusions on the ground that they either violate the cross-section doctrine, the Constitution's Equal Protection Clause, or both, but these legal challenges have so far been unsuccessful. In the context of the ongoing mass incarceration crisis and dramatically disproportionate rates of legal system involvement among specific communities, we must consider anew whether excluding those with felony convictions can be consistent with the right to trial by a jury of peers. Our distinguished speakers this afternoon bring extensive knowledge and experience to bear on this important question, and it's my pleasure to introduce them. James Binal is a practicing attorney, the executive director of Project Rebound, and an associate professor of law, criminology, and criminal justice at California State University, Long Beach. He's the author of 20 Million Angry Men, the case for including convicted felons in our jury process. Brendan Woods is the chief public defender in Alameda County, California, and a powerful advocate for jury reform. And Premal Daria, who will moderate today's discussion, is executive director of the Institute to End Mass Incarceration, as well as the founder of the Defender Impact Initiative, which has worked to engage public defenders in advocacy for systemic change. Thank you, Jamie, Brendan, and Premal for joining us today. Now, some logistics. Following our speaker's discussion, we'll turn to audience questions. You can use the Q&A feature on Zoom to submit your questions at any point during the program. We only ask that you keep your questions brief so we can address as many of them as possible. With that, let's begin. Jamie, the floor is yours.
Thank you, Dean. Good afternoon. Before I start, I just want to say thank you to everyone that made this event possible today. Premal Daria from the Institute to End Mass Incarceration at Harvard Law School, and Becky Wasserman, Maura Madden, Jessica Vickland from the Radcliffe Harvard Institute. I appreciate all of your work hosting and publicizing this event. So thank you all for the opportunity to take part in what I think is a very important panel. I'm also grateful to be discussing this topic with a good friend and colleague, Alameda County Public Defender, Brandon Woods. So this is, I think, going to be a great event. As you heard, I'm currently an associate professor of law, criminology, and criminal justice at Cal State University, Long Beach. I'm also a formerly incarcerated person. In 1999, I caused a DUI wreck that claimed the life of my passenger, who was a college wrestling teammate of mine and my best friend. For that terrible decision, I subsequently spent 4 years, 1 month, and 6 days in 2 maximum security prisons in Southern Pennsylvania. While I was in prison, I took my LSATs in the hope of possibly one day studying law. 6 months after my release from prison, I began my first year of law school. In 2008, after I completed my Juris Doctorate and an LLM, I was admitted to the State Bar of California and began my legal career doing criminal defense work, all the while pursuing a PhD. A year later, in 2009, I was summoned to jury duty for the first time as a California resident. When I arrived at the courthouse on my day of service, and I talk a little bit about this at the beginning of 20 Million Angry Men, I passed through security using the entrance designated attorneys only. And I felt this very strange sense of pride and privilege. Soon thereafter, courthouse personnel instructed me to complete a juror qualification questionnaire. And on that questionnaire was an inquiry regarding criminal convictions, in particular, whether I had been convicted of a felony or a malfeasance in office. I answered yes, of course. Moments after turning in this questionnaire, I was called to the front of the jury lounge where I was informed by the jury commissioner, jury clerk, that I was permanently ineligible for jury service because of my prior felony conviction. I was also told I would never be summoned again. I protested mildly, explaining that I was an attorney. I had used the special attorney's entrance, showed them my bar card, but I was still told that if I had a problem with California's juror eligibility criteria, that I should write my congressperson. Instead of writing my congressperson, I wrote an article comparing jurisdictional juror exclusion policies and bar admission procedures for those with felony criminal convictions. And what I found was that I wasn't alone, right? In 25 states in the federal system, a person with a felony conviction can be admitted to the bar and the practice of law, but is forever barred from serving as a juror in either a criminal or civil matter. I offer this story by way of explanation, by way of introduction, but also by way of explanation about why I've spent the better part of the past decade studying a topic that has received, really up to this point, very little scholarly attention. I also offer this story as the first of several examples of the contradictions and inconsistencies inherent in the practice of excluding those with felony convictions from jury service. When we think about the civic marginalization of folks with prior felony convictions, we typically think first about voter disenfranchisement. Most overlook or simply fail to consider record-based exclusions from jury service. Still, of the collateral consequences that impact the citizen's ability to take part in democratic processes, exclusion from the jury is by far the most pervasive. 49 states, the District of Columbia, and the federal system categorically restrict the opportunity to serve as a juror for those who have a prior felony criminal history. Of those jurisdictions, 26 states in the federal system bar those with felony convictions from the jury process permanently. As the dean mentioned, today, Maine is the only U.S. jurisdiction that places no record-based restriction on juror eligibility. Now, in justifying these statutes, courts and lawmakers allege that those with a felony conviction would jeopardize the jury process because they purportedly lack the requisite character to serve and or harbor an inherent bias, making each adversarial to the state, but also unduly sympathetic to criminal defendants. In 20 Million Angry Men, I set out preliminarily to test these justifications for exclusion, before then exploring the possible ramifications of this practice for juries, for the excluded, and for the communities that enforce these types of statutes. As to the justifications for exclusion, I examined each independently in the book, and then simultaneously using a mock jury experiment methodology. And what I found was that these justifications, which are purportedly intended to protect the jury from corrupting influence, are really not supported by evidence. Rather, evidence suggests that both the inherent bias rationale and the character justification fail when you press them empirically. Again, while several of the studies that comprise the book undermine these justifications, the most damning evidence against exclusion, I feel, arose in the context of the mock jury experiment that really is the central focus of the book. In that study, I found that jurors with felony convictions approach service, even fake service, as it were, in a mock jury experiment. They approach service conscientiously, thoughtfully, and impartially. These jurors brought value to the process. So to be clear, jurors with a felony criminal history didn't undermine deliberations as the justifications assert. Rather, they added to those deliberations by, in particular, recalling more novel case facts and speaking for a larger proportion of their jury's deliberation duration than did their non-felon counterparts. This suggests that, contrary to the stated reasons for exclusion, jurors with a felony conviction do not undermine the process, but rather enhance it. So, jurisdictions that bar those with convictions from jury service, I argue in the book, may unnecessarily be discarding a valuable viewpoint. What the sum of my research on these purposes for exclusion demonstrates is that there is really a lack of threat that those with a felony conviction pose to the jury. Those with convictions, myself included, are not homogenous in terms of our pretrial biases and attitudes. And in the mock jury experiment, did not prove to be liabilities during deliberations. Instead, my participants, my study subjects, demonstrated a typical normal distribution of pretrial biases and took part in deliberations in a thoughtful, considerate way. This research seems to suggest, in turn, that record-based juror exclusion statutes are both over and under inclusive, undoubtedly capturing and expelling those who would make appropriate, even exemplary jurors, while at the same time overlooking groups of potential jurors that may jeopardize the impartiality of the jury. In 20 Million Angry Men, I also look at how juror eligibility criteria impact communities and those with felony criminal histories. In a field study in Maine, again, the only jurisdiction that places no restriction on the ability to serve for those with records, I conducted qualitative research, a field study really, with court personnel responsible for screening jurors, and then with prospective jurors who have a felony conviction. The studies that I conducted in Maine suggest that Maine's policy of inclusion places a premium on individualized assessments of prospective jurors. As participants in the study generally conceived of those with convictions on a case-by-case basis, suggesting that those who had finished their commitment to the state deserved an individualized evaluation of their fitness for service. My fieldwork in Maine also revealed how inclusion in the jury process validated efforts to change for those with a felony criminal history. Participants, again, all with felony criminal convictions, spoke of their inclusion in jury selection as corroboration of their reformation. Subjects boasted about their value as potential jurors and used inclusion as an apt example of how removing barriers to reentry helps one to build a personal narrative that acknowledges a criminal past while also allowing for a law-abiding present. As many scholars have noted, right, this process of reconciling past events with present and future aspirations is a key component to criminal desistance. In sum, my research on record-based juror exclusion, born out of that embarrassing public event, really demonstrates themes common, I think, to collateral consequences and discretionary disqualifications. Namely, that we, my population, are not all alike, and not all of us categorically threaten democratic institutions and processes. These categorical collateral consequences and discretionary disqualifications are rife with presumptions and stereotypes, and really almost always lack a mechanism for individualized evaluation. Guess what? In the case of juror exclusion, we go so far as to jettison an existing process designed to take the time to consider citizens at a personal, individualized level. Jury service, right? Jury selection. As a result, we may damage our jury system. I argue in the book that by barring citizens who could make valuable contributions to a jury's efforts, we sell ourselves short. Moreover, for those with convictions, exclusion makes reintegration more difficult. By designing and then imposing categorical lifetime obstacles like juror exclusion statutes, being perpetually reminded of a criminal past damages one's view of oneself to the point that one with a conviction may find it difficult, if not impossible, to let go of the criminal old and embrace a new law-abiding present and future. To close, look, certainly including those with a felony conviction in the jury process will not fix many of the issues that plague our jury system, our criminal justice system, and it will not assure successful reentry of those who have been that were once part of our criminal justice system. Still, inclusion will very likely aid broader efforts to make juries more representative and to remove obstacles to reentry that tend to dehumanize, categorize those with convictions. And they tend to undermine what it means to be a citizen, especially in this case, and what it means to participate meaningfully in our democracy. Again, thank you for having me. I am open to any questions you may have about the book or any of the other research I've done. For now, I'd like to turn it over to my colleague and friend, Brendan Woods, the Alameda County Public Defender. Brendan?
Great, thank you. Thank you, Jamie, for that introduction, and thank you for having me and having me be part of this panel. So my name is Brendan Woods, and I'm the Public Defender for Alameda County. I've been with the Alameda County Public Defender's Office since 1996. I actually went to law school specifically to become a public defender. I wanted to take action and do something about the way I witnessed this criminal legal system exacting harm and violence on my community. I witnessed this through abusive police practices, through over-policing, the way the police targeted communities of color, through unjust and outrageous punitive sentencing, through 3 strike laws, the war on drug, mass incarceration. I wanted to make sure that I did something to fight against a system that was allegedly set up to offer protection, but was in fact creating more harm. So I started out as a public defender in our office, and I did every assignment. I handled misdemeanor cases, misdemeanor trials, felony trials. I moved up and handled death penalty cases. I've been assigned to our law and motion research unit. I've been in charge of our felony trial staff and recruitment. I've supervised lawyers, and I've done almost everything in this office. And so in 2012, I was fortunate enough to be appointed by our Board of Supervisors as the public defender of Alameda County. So when they made that decision in 2012, I became the first Black chief public defender of Alameda County. And when you think of Alameda County, that includes Oakland and Berkeley, that says a lot that it wasn't until 2012 that a Black person held this position. And now, for the last several years, I am currently the only Black chief public defender in the entire state of California, the entire state. So I say all that to provide you with some context as to why I became a public defender, why I do this work, and why I am completely honored to be on this panel today, and also to pull back and tell you racism and race is a big motivating factor in regards to why I do this job. Our criminal legal system, along with so many other systems in this country, whether it be child welfare system or healthcare system or immigration system, is steeped, and I mean steeped in systemic racism. And we have to recognize and understand the role of racism, the role of white supremacy, and how they have played major impact in this nation's history. And that these systems are built and designed to uphold a certain order. And I think it's most visibly apparent in the criminal legal system, in which in this system, we're taking predominantly Black and brown people and placing them in cages in the name of public safety. If there is one thing, one thing, if we figured out how to do really well in this country, it's how to incarcerate people. As you heard earlier, we in this country incarcerate more people than any other country in the world. Our rate of incarceration is more than 5 times higher than most of the countries in the world. We incarcerate about 2.3 million people annually. And that incarceration extends to systems of control. This carceral state, this correctional state, where there are nearly 7 million people under some form of correctional control right now in the US, and 2.4 million of them are Black. So people want to debate and they want to argue about whether this country is racist. And I don't understand the underpinnings of the argument. I don't. You cannot pull back and look at what happens in our criminal courts and see the results it produces and come to any sort of rational conclusion that this country is not racist. So think about it. People of color make up about 30% of the US population, and they account for only 60%. I'm sorry, and they account for 60% of those that are imprisoned. 1 out of 5 Black men are in custody right now, as opposed to 1 out of every 106 white men. Black men convicted of crimes receive on average a sentence 20% longer than similarly situated white men. There are more Black men in prison and jail or on probation or parole right now than there were slaves before the start of the Civil War, and it's not even close. It's not even close. Those racist results, racist outcomes come from a racist nation, and there really isn't any other argument. With that incarceration of predominantly Black and brown people comes the inevitable stripping of certain rights that a normal citizen would have. So I'm going to back up a little bit and go back to when I first started being a public defender. And I remember walking into what we call North County Jail. It's in Oakland, and it's a big jail. And I remember going into the holding tank, and the holding tank was kind of the size of a large living room, and immediately being hit with this visual of 20 to 30 Black faces. I'm thinking, oh my God. You know, you hear about how bad the system is, and then when you see it like up close and personal like that, it is kind of overwhelming. So in that moment, I was depressed, overwhelmed, but also extremely fired up to go out and fight for my clients, to go out and start trying cases and to begin liberating my people, really. And then you go to trial and you set cases for trial, and you're in the courtroom and you're seeing all those Black faces in jail, and you're seeing these jury come in, and there are no Black faces in the jury. You're in Oakland and you're walking around town and seeing there are Black people, and there are no Black people on the juries. You know, to highlight this point, you know, there's an African-American woman in my office who has tried over 20 cases. More than 50% of our clients have been Black, and she can count the number of Black jurors on one hand. You know, we've had cases where out of 57 potential jurors, there have been 2 Black jurors. We had another case where out of 92 potential jurors, there were 3 Black jurors. And I said Alameda County, you know, it includes Oakland, Berkeley. It is a diverse city. We think of Oakland as a predominantly Black city, but when you're trying cases here, there is no Black representation on juries. You know, during COVID, over the last year, we did a lot less trials, and we were able to really dive in and collect data with regards to race in our trials. So we did about 33 trials in the last year during COVID, and we got good data on 23 of them. 11 out of the 23 trials did not have a single Black person on the jury. Of the 276 people who actually served as jurors, who sat in judgment, the 12 in the box, only 16 were Black. We had 7 Black clients go to trial and not have a single Black person on their jury. So I say all that to highlight the fact that Black people, people of color, low-income people are overrepresented as being prosecuted and charged with crimes, and are completely underrepresented as serving as people on our juries. When I was a sophomore in college, my uncle got sentenced to 27 years in prison, and there wasn't a single Black person on his jury. So this is why, to me, being on this panel is important. Prior to us in California passing a law, SB 310, over 30% of Black men, in California were banned, excluded for life from serving on jury duty because of a felony conviction. The conviction didn't matter how old it was, what you've done with your life since then. It didn't matter. You were banned. And so we have this concept of a jury of your peers. You know, you will be tried by a cross representative section of the community. It doesn't exist. And it doesn't exist as long as the felony exclusion rule is in place. So all that being said, I am really happy to be here. I'm happy to be here with Jamie. And I'm now going to turn it over to Premal Daria, who is the executive director of the new Institute to End Mass Incarceration at Harvard Law School. And we're going to start this new virtual conversation here.
Thank you so much. Thanks to both of you for your opening comments that were so powerful. Thank you all for joining us today, and to the Radcliffe Institute for co-hosting this with the new Institute to End Mass Incarceration. We're thrilled to be co-hosting this conversation and to bring you these experts to discuss these important issues. The title of the talk, as you have now discerned, certainly is based on Dr. Banal's book, 20 Million Angry Men, which is important in so many ways, but is, of course, especially timely now as we grapple with the crisis of mass incarceration that we've built and how to go about dismantling it. And so without further ado, I want to begin the conversation with our guests, and I'm going to start with Dr. Banal. You told us about your own background and what sparked your drive to engage in some of this research and writing. Thank you for sharing that compelling personal story and background. In your book, you essentially seek to answer, as I can tell, two main questions. One, does the research support the justifications for these exclusions? And two, what are the consequences of these kinds of exclusions? So with respect to the first question about what the research supports and whether it supports these exclusions, you went into, in your research, a bunch of different areas of juries and how they operate, attitudes that people bring in, how they engage. Could you tell us a little bit more about those features of the research that you did and what you found?
Sure. So the bulk of my work on the justification, so let me back up. The two justifications, really, the character rationale and the inherent bias rationale, one is sort of confused, the other is relatively clear. So the character rationale is sort of confused. Some courts suggest that maybe it is a lack of character that impacts the function of the jury, right? Won't follow jury instructions, won't comport behavior to what the law requires to be a juror. The other possibility that folks have floated is that, in fact, character is more about the appearance of impropriety. That if we include these folks on juries, that in fact, the public, whomever, will look at juries with a skeptical eye. The verdicts may not be seen as entirely legitimate. And I can talk more about that. I'm actually conducting a study right now. Preliminary results say the opposite is in fact true. But when we talk about, so most of the inherent bias rationale, though, is more clear, right? The claim is pretty straightforward. If we were to put someone with a felony conviction on a jury, the tendency would be for them in a criminal matter to acquit, simply because they have sympathy for criminal defendants and have this adversarial relationship with the state. Now, because those statutes are categorical, that really does make a few assumptions about those of us with convictions. One, that we're homogenous with respect to the direction and strength of our pretrial bias. The fear is pro-defense, anti-prosecution in a pretty big way. The second assumption is that we, as a group, pose really a unique threat to the jury process, more so than any other group that you might suspect has similar or the same biases. I tested this by looking at group level biases for law students and for law enforcement personnel and comparing those to folks with convictions. And what I found was there was no statistically significant difference between law students and folks with felony convictions with respect to their pretrial biases on a sort of validated measure of pretrial bias scale. So what does that mean? Should we exclude all law students from jury duty as well? I mean, that seems to be where this goes, right? When we looked at law enforcement personnel, we saw the opposite, a pro-prosecution bias that was equally as strong as the pro-defense bias that we found that existed among formerly incarcerated people, or excuse me, folks with convictions and also law students. All of this is to say that my evidence, my research suggests that we don't pose a unique threat, all right? And this is the under-inclusivity piece of this, the under-inclusive piece of this, is that there are other groups that harbor biases that, if you suggest our group level biases would threaten the jury process, theirs would as well. So what do you do with those folks? And then finally, the last assumption that I think these types of categorical restrictions make in terms of bias is that anyone who's been convicted of a felony conviction will necessarily comes to this with a pro-defense, anti-prosecution bias, that it is a dispositive predictor of that type of bias. We found that the formation of pretrial biases is a holistic thing. that multiple factors, demographic and otherwise, come into play to determine what direction your pretrial bias is in and how strong it is. So all of this is to say the justifications found no support. And the book really does detail how I went about trying to systematically test those justifications to see really if there was anything there. And there was not.
Thank you. Just want to ask one follow-up question about that. You also, in the book, researched and discussed a bit the different approaches to actual engagement in the jury room in deliberations that people might have. Could you talk about that for a minute?
Yeah, so what really did surprise me in terms of the mock jury experiment that included folks with felony convictions was that all of our participants with convictions disclosed their status to their fellow jurors almost immediately once deliberations started. My fear, being someone who has a conviction and lives in this world, was that the fear of stigma, the fear of prejudice in the jury room would push folks to keep that quiet, right? To not disclose their status in the jury. They didn't. And in fact, they drew on that status in analyzing evidence. And then I argue even-handedly applying the law, right? They talked about our defendant in the case, our defendant in the case was on parole at the time that this alleged offense happened. And talked about having to report to his parole officer. And if he didn't get there on time, there would be ramifications. Folks without felony convictions in the room who had never been on supervision really didn't understand that exchange. What we had was folks with convictions standing up at a whiteboard talking about this is what it means to report to a parole officer. This is what it means when you abscond. This is what it means. So using experiences that were otherwise negative as really a valuable source of knowledge and helping their fellow jurors sort out the evidence and come to a just conclusion.
Thank you. I want to turn to Brendan Woods for a moment. Brendan, you shared some of your background about why you became a public defender in your career. Thank you. As a former longtime public defender myself, I'm particularly thrilled to hear all of that and to have you here with us today. I wanted to just ask sort of a practice question, practical question about juries. Given your experience in the courtroom and experience representing people who are entangled in the criminal legal system, can you tell us where the origins of the right to a jury or the jury trial come from and how that functions in real life?
Sure. I think it goes back to our Constitution and England and the Magna Carta, and it goes way back. I think how it functions in real life for me, as a public defender, you get a criminal case and you're assigned to it and you represent your client. And one of for me, sometimes even more important than the facts of the case itself is the jury, the people who are going to be sitting in judgment, the people who are going to be deciding your client's fate. And, the jury is composed of alleged cross-section of the community. People are called in to serve. There are reasons why people can get out of service. And then you are there with your client and you're going through this whole jury selection process. And you're trying to come up with a jury that is fair and is going to judge the case. And what I think the average citizen doesn't realize is that there are so many barriers in place that exist before you even get to that jury selection process that exclude people. One thing is what we're talking about here is a felony exclusion. And because of that, you are stripping away a certain segment of potential jurors that really have a valuable voice, a valuable perspective, and a valuable contribution to make to any sort of criminal case or civil case. And we don't realize that there are certain experiences that are just being wiped away and not being heard in criminal trials. One thing I really like the best about a criminal trial is sitting down and going through jury selection and learning about people and figuring out who is going to be the best people to serve on the jury.
Thank you. Going back to Dr. Bindel for a moment, I want to zoom out for a minute. And, I think that the most well-known form of exclusion is one that you touched upon in your earlier comments around voting, exclusion from civic participation, that most people are familiar with is around voting. And I would guess that most people in the audience here today are familiar with that generally. And so I wanted to ask you if you could talk a little bit more, expanding on your earlier comments about the similarities and differences between sort of in the rationales and justifications for these exclusions, and how we can think about the framework that the voting exclusion work and advocacy has provided as we think about juror exclusion.
Sure. So, I mean, from the outset, the contexts are very much similar, but there's some fundamental differences, right? I mean, first, this sort of fundamental right of voting versus not a fundamental right to serve as a juror. And then, obviously placement in the Constitution, lots of different differences. But you're right to point out that really the rationales for disenfranchisement on the voting side and disenfranchisement on the jury side really are sort of the same flavor, right? The idea is that we are trying to protect these institutions from the bad people with the felony convictions who will infiltrate these systems and will somehow corrupt those systems in a way that benefits their population, however defined, right? And so I think the fear, right, on the voting side is ballot manipulation, possibly electing someone who is quote unquote soft on crime. Maybe there's some sort of, voter fraud, right? On the jury side, the character rationale speaks to much the same sorts of concerns, that someone will get into the jury room and engage in nullification, will disregard jury instructions, will otherwise sort of flout the law, right, in the face of what they're told to do. Also, sort of in the bias side, right, we're talking the same thing about the function of the jury, that this really all is about corrupting a process. Just like on the voting side, there is no evidence that I found that supports that there is this threat, that this threat exists in any way. And I will say, as we zoom out, right, this is, I think, part and parcel for sort of how we treat folks with convictions. We love to talk about the deficits that people with convictions have, right? They're missing this, they're not good at this, they're whatever it might be, right? And we talk very little, I think, more so these days about the strengths and attributes of people who have been inside and people who have felony convictions. We are a resilient bunch, and we bring, I think, at least the book demonstrates, value to these processes. And really, the threat is minimal to nil.
Thank you. I want to go back to Brendan for a minute and to sort of follow up on that. I think what Professor Banal was describing, this issue of sort of like character, right, or corruption is the word I think that you used, Dr. Banal, of something equating having a prior felony conviction with anything to do with character or how one might behave or act or anything like that. That framework, I wanted to ask you if it appears anywhere else. Like, does it appear anywhere else in the law, in the criminal law, as you see in your kind of day-to-day work, standing beside people who are charged in the criminal system and seeing the daily impact on people's lives, Brendan? Do you see that issue of character coming up in other ways? Is it consistent or inconsistent with how we've been talking about it here and the concerns that Dr. Banal has raised?
I think it's completely consistent. And you probably noticed one thing I do is I focus on race a lot and the way my Black clients are treated as compared to the way my white clients are treated, the way affluent people who come to the system are treated as compared to those who don't have any resources. And there's definite disparities in how they're treated, disparities in how they're charged, disparities with regards to who ends up with a felony conviction and who doesn't. They all exist. And then it comes down to, once that conviction is then on your record, how you're treated after that. And these exclusions are one way we see it. There's so many barriers that are put in place for people who, once they have these felony convictions, it's very hard to overcome. And one thing I really appreciate about in Dr. Banal's book is that he talks about how the civic engagement is really a major step towards rehabilitation. And one thing I want to go back to, if I can, Premal, with regards to the question around maybe voting and jury service and how they're different, but how they're also interlinked. I do want people to understand and consider and think about this. I don't think there is a more important civic duty or civil responsibility than jury duty. If we think about voting, you are not summoned to vote. Voting is voluntary. You are summoned to come serve as a juror. You have to come. The government essentially has the power to subpoena you to come participate. And I do give jury service more weight, because it's not like voting where you're voting on someone and it'll have some sort of impact later on. You are now voting real time in the moment, and you're going to have a significant immediate impact on someone's life right then and there. And so I almost don't see anything more important as far as a civic duty than serving on juries. And if we extrapolate a little bit more when we compare voting and jury service, we see how the system kind of cannibalizes itself. We set up these rules which prevent you from voting. And then people who vote set up these policies that are more draconian, and they end up punishing Black and brown people. And then Black and brown people go to criminal trials, and there's no one who is going to be sitting in judgment on them because they're prevented from serving as juries.
That's a perfect segue to my next question for Dr. Banal. We've talked a bunch about sort of the justifications and how your research demonstrates that they don't really add up, right? They don't make sense when you actually look at the evidence and move away from the kind of emotion, fear, and assumptions and stereotypes that people might have. I want to talk for a minute about consequences. And you know, one of the things you wrote about in your book is how Alexis de Tocqueville described jury service as a school for civic engagement. And I found that really compelling. And I was wondering if you could talk a little bit about how jury participation can actually lead to increased engagement in communities and political activity by people who have been able to serve.
Yeah, so some political scientists have done some great work on what, you know, after we engage in jury service, does this prompt additional interest, participation in civic processes? And what they found was actually anywhere from a 4 to 6% increase in voting rates for folks who had previously served as jurors, right? Had been in panel jurors. You know, for members of our population with felony convictions, you know, I think that statistics bear out that many folks in that population have been detached, right, from these civic processes. Maybe they haven't engaged the way you would expect or the way you would hope. And that this impact of sort of a taste of civic engagement through jury service and what that can mean in the future really is most impactful for people who maybe were a little bit disassociated with these civic processes prior to. So I think it can have a tremendous effect. One thing I will mention, though, I mean, like in California, right, we passed SB 310, rights are now restored. One of the things that if we are talking about possibly lifting this legislation or altering it such that folks with convictions can serve, I think it's very important how we make that change. And I know we're probably going to talk about it in a little bit, but the idea that we need to notify the folks who are now eligible in appropriate ways, and we need to notify courthouses in appropriate ways, right? So that everyone is on the same page. You know, some folks on the voting side have written about de facto disenfranchisement, where people just don't have any idea that they're still allowed to vote, so they assume they can't and they don't go vote, right? Even election officials, and Alec Ewald up in Vermont wrote about some folks in New York who really, even the election officials didn't know the rules, right? We see if the notification isn't appropriate or correct, this sort of de facto gerrymandering, right? Or this de facto, I'm not going to show up because I simply, right, if I'm a person who hasn't been notified, simply believe I can't serve, right? Isn't that the policy? So I know it was sort of a roundabout way to answer your question. I apologize, but yeah, so that's what I think about notification and about serving.
Thank you. So I think it's time to move into some of these questions. We've got a lot of really great questions from our audience here. A few different people have inquired about states other than Maine. You know, what makes Maine an outlier? How can other states learn from their policy? And what are the experiences of other states along these lines, if any? Could you speak to that?
Yeah, so I thought a lot. I grew up in Boston, and so I spent a lot of time in Maine, and I thought a lot about what made Maine different, right? Without offending any Mainers, right? I mean, they have a sort of way that they do things up there that is very straightforward, and so when it didn't surprise me that Maine was the only jurisdiction. I will say, and I want to offer a caveat to Maine being the only jurisdiction. In Colorado, folks with felony convictions are allowed to serve on petty juries. but they are restricted from ever serving as grand jurors. So Maine is really the only pure state that it doesn't even have a statute speaking to folks with convictions serving. Why do I think Maine is that way? I mean, when they broke off from Massachusetts, they were still a permanent exclusion state. It wasn't until, I believe, and I'd have to look, I apologize, I don't know this off the top of my head, but it was in, I believe, the early 70s when the restriction was really lifted, and there has not been one since. In terms of how Maine functions, I mean, really, this isn't an issue for them. When I spoke to judges and attorneys about jury selection in Maine, they really thought of folks with convictions really as anyone else. And it wasn't a topic they had ever considered. They knew on the federal side in Maine, folks with convictions were excluded permanently, and courthouses were right across the street from one another in Portland. But they also knew that in Maine had never done this, so it really wasn't an issue for them.
Thanks. Brendan.
Can I add to that a little bit? I'm such a cynic. And I love Maine and Vermont. They always come out like doing great stuff around this. But
90% white, right, Brendan? Yeah.
90, yes. Yes.
No, fair enough. Yes.
Maine, I think, is like 1.2% black. So I do believe there is a reason and purpose with regards to why these exclusions exist. And it goes back to history. It goes back to slavery. It goes back to when juries were comprised of all white men in order to convict black men. That's how that came about. And if you have a city or state where it's just 1% black, not concerned about it. You're just not. So I do fall back, and I know, yes, so I do fall back on that, and that's why. I appreciate what they do. Needs to be done more places.
Yeah, thank you for making sure to include that important point. I appreciate that. I want to ask you a question there's a few different people who have kind of gotten at this question, so I'm going to sort of merge them into one question, but it's basically about what the differences are between, excluding people with felony convictions versus the possibility that they get excluded through peremptory challenges. And what do you do with the fact that there's another way to exclude people, and what are the differences in those processes? If you've seen it all from your experience in California with SB 310 or have thoughts about that more broadly.
Sure. So I think for me, as you can tell, the big issue that we're trying to do, that for me, why this was a huge issue, was just making sure that people with felony convictions, Black people, had the ability to serve as jurors. Yes, prosecutors are going to remove people of color. They're going to try to for multiple ways. They think it's better for their case. And if there's a pattern of them doing it for X reason, we can object and make our record. We've had some really great changes in the law in California with SB 310, the felony exclusion, and then also a new law that goes into effect next year around limiting, a little bit off topic, the Batson-Wheeler process with regards to other reasons why prosecutors might exclude Black people from juries, whether it be based on their neighborhood or some other perceived bias, like not or believing police officers engage in discriminatory conduct or racial profiling. Those reasons can no longer be used. I think you can make a similar type argument or objections around excluding people based on felony convictions. We haven't quite gotten there yet. I think, unfortunately, when SB 310 got passed, we moved right into pandemic world. And so trials just came to a grinding halt. And now we're starting to get back up on that. One thing Jamie mentioned earlier, and Professor Bennell mentioned earlier, was the outreach and making sure people are aware of this. I went back and dug up old emails that I had. We were in the process of trying to make a outreach video about the people with felony convictions now have the right to serve as jurors. And it all came to a grinding halt in March. Everything stopped. And now I'm like, hey, we got to get back on that. So.
Right. Did you want to add something?
I've called my agent for that video, so we're all
good. There are some questions, Dr. Bennell, about the findings that you described about the impact of jury exclusion for successful kind of building up of life after coming home, successful reentry. Can you talk a little bit more about what the research has shown about that?
Sure. Yeah. And I make a point here that has been made on the voting side as well, right? Chris Eugen, Jeff Manza make this argument and Locked Out. And then believe later articles, the idea that, when we vote, when we serve as a juror, that's a role, right? The ideal voter, the ideal juror. And when we take on that role and we attempt to live up to it, right, there are certain strictures, right, of that role that suggest that we have things that we have to do and certain things that we can't do if we're going to live up to this ideal version of this role. And eventually, right, we start to take on this identity and we start to see ourselves as more productive and less anti-social, all of it. The self-concept change is really what I'm getting at, and what I think the folks on the voting side got to. And the idea was that really, yes, allowing folks to serve on a jury that have a felony conviction is not going to alter their self-concept in significant ways, having served on a jury once, right? But being excluded from jury service is really part of this like tapestry of exclusions. And when we look at them together, what it really says is we have a lot of flaws, our population, and that we shouldn't be involved in a lot of this stuff for fear that we may somehow corrupt all of it, right? And when those rules, right, those exclusions, those can impact how we feel about ourselves and how we adjust our self-concept to view ourselves not as criminal, but as now pro-social contributing members of society, right? When you're reminded of this in a sort of almost permanent way, with these collateral consequences that are categorical and trigger as a result of a conviction, it can be really hard to start seeing yourself as pro-social and to make the changes necessary to successfully re-enter. And that's really what I was getting at. And there's evidence of that in other, when we look at other collateral consequences, most relevant, I think, on the voting side, there's evidence of that as well.
Thanks. Tapestry is such a powerful visual word. I really appreciate your use of that. There's a question that's fairly practical, but I think will be of interest to lots of people who've asked questions about the parallels between voting and jury duty. Where do states draw their jury roles from? Are they related to the voting roles? Where, how are people getting identified as potential jurors or potential voters?
Brendan or me?
I'll start. That's a great question. Every state's different. Like for example, in California, we do it based on DMV, California ID. We've now added tax filers to that. In the original SB 310 bill that we tried to get passed, we did expand that group. We add people with felony. They got rid of the felony exclusion. Then it also was supposed to add tax filers and people who pay utility rate payers. We wanted to really expand the role. Each state is different. Each state needs to expand more, I believe, if you want to really create a true diverse jury pool. So we need to be doing more outreach and expanding more. But historically, it usually comes down to voter registration, DMV, and license.
And uniquely in Maine, you can volunteer for jury service. And about half of the folks that I interviewed with convictions had affirmatively volunteered to be put back on the rolls or to be included, to ensure they were never taken off by mistake. They were never supposed to be. So yes, you can volunteer.
Thank you. It sounds like our audience was also moved by your use of tapestry. There are some questions about the tapestry of exclusions, and if you could expand a little bit on some of the examples that might fall into that tapestry.
Sure. Yeah, absolutely. And I think, again, Alec Ewald has done some great work on this, and a number of folks, Michael Pinard. So there's a whole bunch, right, of record-based restrictions that are triggered as a result of you having a felony conviction. Yes, checking the box for employment applications, checking the box for higher education applications, although that is slowly being removed in about 5 or 6 jurisdictions, I think, to date. Any apartment applications, right, for housing, any public assistance, any public housing, all the record, it isn't a categorical denial in all those instances, but it does impact your opportunity to access those services, right? Or to access those opportunities. Others, obviously voting, which is again, slowly disintegrating, kind of going away. Less and less states are restricting voting. Jury service is the most pervasive. The ability to run for office exists in a few jurisdictions. And then, of course, all kinds of occupational licensing barriers beyond just checking the box to get your job, right? Jobs are great, careers are better. What happens when we want to move into a career for folks with convictions? Oftentimes that's when the gates come down for the professional licensing, and then there's issues there. So again, I could talk about collateral consequences till tomorrow. There are so many. there's a whole lot, and they trigger differently depending on the type of conviction and a number of different things, all right serve to make it a little bit more difficult in the long run to start viewing yourself as a regular old citizen rather than someone who's committed a criminal offense.
Thank you. I think that I'm getting a prompt to move on from these questions. There are a tremendous number of really great questions from a very engaged audience. I think maybe we have time for one more. Oh, great question for this Institute to End Mass Incarceration and Radcliffe Institute program. Is this research and are these findings making their way into law schools and into universities? Are people who are up and coming practitioners and experts in this field are learning about these things so that we can move forward with making change?
I hope so. I've done my part, I think, to try to, take advantage of this virtual platform during the pandemic and get to as many schools as I possibly can over the last 6 or 7 months since the book has come out, or even since before the book came out. So I'm giving it a shot. I think the book does have a place in criminal procedure classes, in trial practice classes, that any class that really speaks to how we select our juries and what juries are supposed to sort of look like, right? So yeah, I hope so.
And Brendan, related to that, you do so much community activism and community engaged work as a public defender. Do you have any parting words of wisdom or encouragement for people who want to take action in this area, who are motivated and inspired by what you've both shared today? There are a lot of questions about what can we do? What can we do on this issue? It's very compelling.
Yeah, so I think thinking about last year, and there was this real national racial awakening around racial justice and what to do. I think extending that to juries and the power of jury service, and how if you want to have an impact, don't try to get out of jury service. Come, show up. I mean, do your part. I've been tweeting a lot, Black Lives Matter on juries. Yes, Black Lives Matter on juries. If you care about ending mass incarceration, show up for jury service. If you care about some sort of racial justice or racial equity in the courts, show up for jury service. People who are like-minded and care about these issues shouldn't be avoiding doing that basic work that needs to be done. So, and with that, I got to go back to Jamie. Professor Bunnell, I've been a fan of his forever. He's written prolifically about the subject. I thought it would take 10 years to get something like SB 310 passed, but his work made it a lot faster. And so the research is out there. If you care about these issues, start researching, do it. And there's community that'll be behind you to support it. There's so many ways in which we can make our juries more diverse and more representative. This is just one of them.
Thank you so much. Thank you both so much for joining us today and for sharing all of your expertise and insights and reflections. This has just been a fantastic conversation. I think the audience members agree, given the comments and questions that I've seen. So thank you both very much. And we're going to be wrapping up in just a moment.
Thank you, Pro.
Thank you.
So this concludes our program today. I want to thank our panelists for their presentations and perspectives, and also thank our audience for terrific, engaged questions. In Dr. Bunnell's book, he describes the role of emotion in some of the decision-making around these issues. And I just encourage everyone to think about the role that emotional appeals and reactions can play, and how important it is to disrupt those narratives of fear and emotion, particularly as our country grapples with undoing the decades of harm caused by our criminal legal system. I think both of our distinguished guests today have done a great job of encouraging all of us to think more critically and about what the evidence demonstrates as opposed to what narratives of fear might demonstrate. Today's program has been recorded and it will be posted on the Radcliffe website in about a week. Thank you again for joining us, and please take care.